Nestle, the food and drink company, won a domain name dispute for nes.cafe by relying on a seldom used but important concept known as spanning the dot. The issue relates to the first element of the UDRP, the Uniform Domain Name Dispute Resolution Policy, which requires a complainant to prove that the disputed domain name is identical or confusingly similar to a trademark in which it has rights. Now, usually this means that only the second level portion of the domain name, the characters to the left of a top-level domain, or TLD, which an accused cybersquatter has actually registered, are compared with the trademark, ignoring the TLD itself, such as .com. In fact, the WIPO overview clearly says that the TLD is viewed as a standard registration requirement, and as such is disregarded under the first element confusing similarity test. But in unusual circumstances, this is not always the rule. As the WIPO overview adds, where the applicable TLD and the second level portion of the domain name in combination contain the relevant trademark, panels may consider the domain name in its entirety for purposes of assessing confusing similarity. That's what happened in the Nestle case for nes.cafe, which was filed at WIPO and resulted in a decision ordering transfer of the domain name in March 2023. According to the UDRP decision, the complainant is part of the Nestle company, which was founded in 1866. It's a Fortune 500 company and it markets its products in 186 countries. The decision also says that the NESCAFE brand was launched in 1938, which is one of the company's leading brands and is protected by a large number of trademark registrations. The company's own website at nescafe.com includes a history of the NESCAFE brand and describes it as the world's favorite coffee and says that it was even the first coffee to land on the moon as part of the Apollo 11 mission in 1969. The UDRP decision says that the domain name was registered in 2015 and that it resolved to a parking page with sponsored links, although it did not say whether those links were related to the NESCAFE trademark. Interestingly, when I visited the website at www.nes.cafe shortly after the decision was issued, but before the domain name was to be transferred, the sponsored links related to the Nintendo system and game console, which presumably could be associated with the Nintendo NES, or Nintendo Entertainment System, which is a home video game console, of course. It's unclear whether these links were present when Nestle filed its UDRP complaint, or whether the registrant of the domain name tried to create a defense that the second level domain NES related to Nintendo and not to NESCAFE. That's an intriguing issue, but it did not seem to arise in the UDRP case. In any event, the UDRP decision says that Nestle tried to purchase the domain name from the registrant in 2022, after which the registrant requested $150,000. As a result, Nestle sent a cease and desist letter, which went unanswered, and then it filed the UDRP complaint. Now, in evaluating whether the domain name was identical or confusingly similar to the NESCAFE trademark, the UDRP panel first acknowledged that, as the WIPO overview says, the top-level domain, in this case .cafe, is typically disregarded. But the panel then cited a number of previous cases in which the TLD was not ignored because the relevant trademark spanned the dot or included elements of both the first and second level domains, such as decisions involving the domain names zionsbank.holdings, mr.green, creditmutuel.group, and test.co. Interestingly, the panel did not cite one of my favorite cases on this topic for the domain name b.mw. In any event, here's what the panel concluded. In some limited circumstances, as part of a holistic review of the facts, it may be appropriate to span the dot and consider the TLD. After reviewing the prior decisions, including those discussed above and those cited in the complaint, the panel finds that the disputed domain name nes.cafe, considered in its entirety, is confusingly similar to the complainant's NESCAFE trademark. The panel then went on to find that the respondent lacked rights or legitimate interest in the domain name and that it registered and used it in bad faith. The panel appeared to give no credibility to the respondent's assertion that NES was an abbreviation for an ambiguous project called New Epic Standup, and instead focused on the strength of the NESCAFE trademark and the registrant's offer to sell the domain name for $150,000. The complainant's NESCAFE trademark is very well known. The respondent does not assert that he was unaware of the complainant or the NESCAFE trademark when he registered the disputed domain name. It appears to the panel that the value to which the respondent seeks to secure from sale of the disputed domain name is based on the underlying value of the complainant's trademark. So, given the expansion of the number of top-level domains in recent years, and there are now more than 1,500 available, from .AAA and .AARP to .Zurich and .ZW, it's not surprising to see disputes in which a trademark like NESCAFE spans the dot. It's an issue that all trademark owners should be aware of when seeking to protect their brands online. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.